Okay. Um, well, I guess our first order of business is to welcome Judge Jones to our group. Um, he will be the judicial representative playing the role that Judge Freeman has been playing. Some of the administrative duties at the court have been changed around a little bit. I'm sorry, I'm trying to get my failing battery plugged in. Some of the administrative duties at the court have been changed around a little bit. And so we're going to be working with Judge Jones, which is great from my perspective. I've known Judge Jones, also called Evan, for a long time. And he has a small background in civil practice, but an extensive background in prosecution. He was with the prosecutor's office until he was elected to the bench in 2020, right? Yes. And as a prosecutor it just did a very good job and was very focused on criminal justice and in the larger sense, the sense of trying to do right by society and by the defendant and achieve justice. And so I really enjoyed working with him in his capacity as a prosecutor, and I'm looking forward to working with him in his capacity as a judge. So welcome, Judge Jones.
Thank you, Judge Garrett. I appreciate that. I've never heard anybody say such nice things about a prosecutor before, so that's appreciate that. And I'm really looking. I know it looks like I know most of the folks here, so I'm thankful to Judge Freeman for inviting me to kind of take some of the duties that I know he cared a lot about, but were becoming just a lot for him to do. So I was happy to get his invitation to help out where I could. I'm very much interested in the issues that you all have been discussing. I'm excited about being involved and making changes. I've already started working with this is a real opportunity in Superior Court now as we kind of redefine our pretrial services department and what that's going to look like for the benefit of those that find themselves charged with crimes, but also the community. So I'm really looking forward to being involved.
Well, and that's exactly what I was going to say. We are at something of a pivotal moment now because we have a pretrial services department that we are not utilizing to its full potential. I think that's something we can all agree on. And I think Alan would probably be the first to agree with that, which is not to say that you all are not busy, but this group, we're an advisory group. So the decision makers here are the judges, and Judge Jones is here as their representative. Our committee makes recommendations, and my experience has been that the judges take those recommendations pretty seriously, but ultimately they run the court. And so our decisions are advisory only, and they're the ones elected to do the hard stuff. And so for a variety of reasons, I feel that the court is not utilizing our risk assessment tool to the full, to achieve the full measure of advantages that tool confers. And that's been for a number of reasons. And I think rather than figure out why that is, the thing that we should do is try to figure out how that can be addressed, how the concerns that have motivated the court's commissioners, particularly, not to use the assessment as fully as we'd like them to, how that can be addressed in a way going forward. The court's commissioners are in as a group excellent, and they know what they're doing. So it's a question of figuring out how this tool, which is meant to be a huge advantage for decision makers, can be fully utilized in a way that works for everybody. Our group has not made huge decisions recently, but we adopted the the public safety assessment tool several years ago and installed all of the computer software that goes with that and trained our people to use the risk assessment. We've been working with Dr. Andrew Peterson Dr. Peterson is, I always say he's a demographic statistician. I hope that's my impression of his expertise. Dr. Peterson is with the court administrator's office, and he has worked on risk assessment tools before, but he's also worked on simply evaluating data, demographic data from jails. And it's that data that lets us know what the population of people is who've been incarcerated by age, ethnicity, gender, by crime charged, and by bail or other pretrial conditions assessed. And so he's played a vital role in our figuring out what the pretrial assessment should be and how we want to utilize the pretrial services department. We're going to be losing Dr. Peterson because his workload at the state level has changed, but we're optimistic about securing the funding that we'll need to employ a consultant to utilize Dr. Peterson's data and the current data that we'll be giving now and in the future to make sure that our use of the pretrial risk assessment is what we want and that it's not working to the disadvantage of any particular group of people, whether that might be
Might have been the plug-in that Judge Garrett was worried about.
Yeah, Jill, could you try to text Judge Garrett or somehow reconnect with her?
Number for her. I'm sure she'll reconnect as soon as she can.
I'll finish that sentence. So it was not disadvantage any group based on race or any class that we can measure. Pretty sure that's where she was going.
That sounds right to me.
In the meantime, did you want me to kind of give an update of our department as it sits right now, or should I wait till Judge Garrett comes back? Oh, there she is.
Oh, you're muted again, Deborah.
I'm sorry. This is a good lesson in how to not handle technology. My laptop seems to have died mid-sentence, and now I'm back on my phone. And so, hello, everyone, and I'm sorry for.
It's like you went
You think
muted
you-
again. It's just everything's working against you.
All right, now I think I'm not muted. Is that what you think?
Yes, I can hear you.
Okay, I'm so sorry. I was just apologizing for giving you a lesson in how not to use technology. And so I guess you've all seen the sort of worst case that I've just presented. I'm sorry. Here we all are. And actually, I was hoping that you would get into a discussion among yourselves while I was out. I just wanted to kind of give a background of our work on this committee for Judge Jones and anybody else who's new to our meetings, although most of you look like old friends. First of all, does anybody have anything to say about those things before we move on to our agenda, which is mostly an assessment of the Vera report and the other information that that we've been given about our progress on the Vera report, specifically the the update from the assessment that was done earlier in 2023. Before we get to that, does anybody have any comments to make about where we are so far? Dr. Peterson, yes.
Thanks, Judge Garrett. I think at the last meeting, Judge Freeman had talked about making a connection to the consultant that you mentioned earlier. I hadn't heard from Judge Freeman or anybody, but I talked to the consultant and they're ready and waiting. So if you tell me what the next steps are and I can help make that connection.
Okay, good. Judge Jones, it might be a little soon to ask you about that. Do you know the status?
No, I don't. But I am able to speak to Freeman about what his intentions were, and probably I could be a person that could get connected with that consultant if the contact information is either with Judge Freeman or can be sent to him or directly to me.
Sure, I can do both. Yeah,
Okay.
absolutely.
That's great. Thank you.
That seems good. Yeah. Anything else before we talk about the Vera report and our progress in achieving our piece of the improvement?
Stephen Gockley's hands raised. Stephen, go ahead.
Yeah, I hate to throw Judge Jones into this in his first meeting, but we've talked for a long time about, we got credit in the Vera assessment for having adopted the PSA as a risk assessment tool. And we've talked for a long time about how we're not fully utilizing that. It's hard to sit here and think that we're an advisory committee advising the judicial officers. And we really, I don't think, at least I don't have any understanding what the concerns are on the commissioner's end of things. I don't know how far they extend into the judges' minds themselves. They're sort of, it's a black box from our position as an advisory group, and it's hard to say what we might want to recommend without some communication there to try to break through an impasse here with a tool that we all thought was the best available across the country. So I don't know whether direct communication is even possible or if it's desirable. I don't know if we started using it more, whether we have the staff capacity in the pretrial services unit to manage that. I don't know answers to any of those questions, but I have all those questions.
And Stephen, I think, I'm not sure you were here when I started the meeting, but I basically voiced similar concerns and questions. And it's true that Judge Jones is going to be leaping in with both feet when he's just new to our committee. But that Stephen has put it a little less diplomatically than I tried to, I think. But our group has been concerned that the risk assessment tool is not being fully utilized by the commissioners, and we're not exactly sure why. So we do need some direct communication about that. I plan to sort of lead you into that, Judge Jones, rather than putting it all on you. But we're going to need you to be a key communicator in that regard.
I think that's entirely reasonable, and I want to be. What I said about this being an opportunity, I think as we revamp pretrial services, and I work with Alan and Kelsey to do that, I think the three of us have already discussed needing to educate and meet with the commissioners and provide some oversight in what the judges' expectations are, both in their use of the PSA and also their use of pretrial services. And I don't know if that communication, I think, needs to just happen directly from the judges to the commissioners in the context of here's what pretrial services is, and here's how we expect you to use it. So that's how I'm thinking about it right now, but I know there's a lot that I'm not privy to that has happened in the context of this group over the years. But any suggestions of how to directly communicate, I'm more than willing to entertain.
And I should let you all know that we weren't able to schedule it for before this meeting, but Judge Jones and I are going to meet next week, and I'm just going to tell him some history of our committee and the larger project that we've been working on, but also the history of the pretrial assessment and the work that we've been doing in our committee, so that he has a better sense of the history. But let's talk about the current concerns now. And Alan, I don't mean to put you on the spot, but I guess I sort of do, actually. How are things going? Where is the pretrial service unit in your view in terms of both the workload for you and your coworker, and also how do you assess whether the services you're providing are meaningful, and what improvements could we see there?
Those are good questions. I can tell you kind of just an overview of our department right now. We have, as of when I did these stats 2 days ago, we have 69 on pretrial, 22 are low, 26 are medium, 21 are high. And of those, the highs come in weekly. So we're seeing them face to face. We're making contact with them. We're kind of building rapport with them, seeing if they have transportation issues, if they need help getting into treatment, if they need help getting connected with other things. And I mean, Kelsey just recently has referred more than one person to get cell phones, which was a huge barrier for a couple of these people. So we've aided in that. We've given out, as of, again, I think yesterday, 23 bus passes so far to date, which compared to last year, I think I gave out 0. So I'd say that's quite an improvement. As far as workload, we stay busy with what we have. And I don't want to say that we're too busy to take on more. Obviously, we will take on more, and we need to take on more. And because there's, like you said, if we're underutilizing that PSA and the suggestions are to send nearly everybody, then we'll handle it as it comes. And I think with, as we grow the department, whether it's quickly or slowly, however it grows, we need to adapt policies and procedures along with it. And I'll kind of give an example, like with Pierce County, I talked to them quite a bit. If somebody's on pretrial on high level, which is weekly face-to-face contacts, I think it's the same for them, or at least weekly contacts. It may not be face-to-face, but if they're in compliance for 30, 60, or 90 days, whatever their policy is, they're allowed to petition to the court or to send a notice to the court saying this person's been in compliance, they've done these things, they have this success with us, they've been making their court dates, and they're allowed to step them down. So either go to a medium level, which is less frequent contacts, or just different types of contacts. So if it was face-to-face, it'll switch to phone contacts. If it was criminal history checks every 3 weeks, maybe it goes to once a month, something like that. So as we take on more clients and our caseload grows, I think we'll need to adapt policies and procedures like that in order to be able to maintain the caseload. But I think that's kind of putting the cart in front of the horse right now.
Still, it'll be nice to get to that point.
Yeah. And I know we will, especially with Judge Jones driving it like he has been. I've been talking with him via email and in person and over the phone quite a bit, actually, since he really wants to see this department grow, which is awesome because it gets me fired up about it again as well. Not that I've lost interest, but you know what I'm saying. It's good to have somebody sharing similar motivations as you. And so I've been talking to him and Stephanie as well about making a better intake form. So right now it's in the draft process, but I think we're really close to a better, more thorough intake form, asking really good questions, not just basic generic questions, but good questions that lead to us making better community referrals. So we're working on that. Judge Jones also recommended that we adopt something like Pierce County does for a bench card. And this is kind of going down a tangent here, or a crossroad, but I think the PSA may be underutilized, because just like Judge Jones says, there's the education piece that needs to happen at the same time. They need to have confidence that if it says high, or if it says medium, or if it says low, they need to have confidence that we're doing something with those levels, and what are we doing? So if a piece of paper says high, big deal. you know, they want to know what we're doing with high, and how it's going to help them get to court. If the argument is, well, Your Honor, I don't think this is going to be a good option for him. Well, pretrial can stand there and say, well, this is what we will do to try to help, you know, get him to court and to not commit new crimes in the community. Obviously, everybody has free will. Things, we can't control everything, but we can give them confidence knowing that we are doing something. So I think that's a part of why the PSA might be underutilized right now, is that confidence aspect.
And Stephanie, do you have anything you'd like to add to that? Thank you, Alan.
I think a piece of building that confidence has been Alan and Kelsey are attending court hearings, the first appearances and some of the other court calendars during the week. And so their presence and showing up not only reminds the commissioners that the program is there, but also I think demonstrates that they're paying attention, they're engaging with defendants, and they're ready and able in that moment or the next day when they meet with them to start referring them to services that that individual might be interested or willing to participate in.
Good, good. And Kelsey, anything you'd like to add?
Nope, I'm just taking it all in, still learning.
Okay, but
I-
go ahead.
I'm sorry, I didn't mean to interrupt. I will add a bit more to piggyback on what Stephanie was saying. Along with that, Kelsey was pretty instrumental in giving. So when we show up to those court appearances now, we hand them information about our office. It's not just a business card that says appear, you know, because we're telling you to. We hand them a very thorough explanation of what pretrial is. I used a lot of the information off the website, the county website, as well as our monitoring levels. So when they hear low, medium, or high in court, you know, they might say big deal, or they might not hear anything at all, because, you know, it's probably pretty intense for them to, all they're thinking about is bail, or am I getting out today?
Yeah.
So we're Kelsey or I are giving them a kind of a little packet, and, you know, it shows what we are, what we do, what their expectation is, and then contact information. We give that to them as soon as possible. And
Good.
usually it's right at first appearance.
That's excellent. Because I agree. The people don't hear everything that's said in their hearing because it's so intense for them. And the piece about pretrial services is probably you know, going in at a time when they've hit system overload anyway. So giving it to them in writing, I think is a good idea. And it's good to explain the context rather than just saying, here's how you call pretrial services and leaving them not really knowing what pretrial services even is. So good. Good. Anything further on our present situation and the things we've been talking about?
Judge Garrett, Alan started out with questioning whether we were ready for policies and procedures. I really like a lot of the steps that Alan and Stephanie described, and apparently Judge Jones is already in conversation about. But I don't know why I would urge us to put as much in place as we can. I mean, we know that pretrial risk assessment and referral to pretrial services ground to a halt with COVID because we didn't have a tier of monitoring tools available at that point. But we're getting, if we're not already there, we're getting to that point now. And the more we could flesh out of that, the more we could build a structure so that when we're really ready to go full bore with those referrals, we don't have to start from scratch. We don't, then that would not be the time to write the policies and procedures. Now would be, I would say. I also think that a lot of people, Alan's staff, Stephanie's predecessor, and some others have gotten some training, and Dr. Peterson may know more about what might be available from Arnold Ventures or or even him and AOC, that we could train the commissioners on what exactly the PSA is and how it's intended to function. Because I don't think I suspect they may not have a full picture of that, and so they don't really know what the resource is at their disposal. I really like Alan and Kelsey being there to converse with them as well as the defendants. And the last comment I would make is, I wonder how many of those defendants are really able to process maximally written information that you hand to them. A lot of times they're not functioning on that level of literacy. And so I wonder if there are some alternative ways to communicate a little more detailed information like you're trying to do that way in other ways for people who need it.
You said one other thing, Deborah, I wanted to mention, which I think is a good positive thing, that the court has announced that starting Tuesday next week, we're going to be going back to, maybe everybody knows this, but we're going back to the jail courtroom for the purposes of first appearances every day. So those are the 3 o'clock hearings where folks are told of their obligation to pretrial services, if that's what they're being ordered to do. So they'll have, starting next week, they'll have a judge be face to face with the judge and or a commissioner in a courtroom, prosecutor there, defense attorney there, everybody in the same room, pretrial services there, where that introduction can be made in a way that's more personal and responsive to any needs of the person in that moment, and understanding or just making the introduction in a way that's more meaningful and hopefully helpful. So that's all going to be happening, not over a TV screen like it has been, but in person.
Oh, that's
starting
excellent.
next week. Yeah.
That's excellent. I didn't know that, and I'm really glad to hear it. Thank you.
Yep.
I'm on my phone, so in order to talk, I can't see. I think I saw Carol Donovan's hand up. Is that right, Carol?
Thank you. Yeah, I just wanted to flag a couple things that maybe we've talked about sufficiently in the past, but I lost track of where we're at. And again, I'm always specifically coming from questions around how can we use pretrial services to mitigate risk of interpersonal violence, because that's kind of my piece that I'm always holding with this group. And one question that I continue to have is, are judges considering or willing to consider referring to pretrial services and also setting bail? And specifically what I think I'm seeing in a lot of cases is when bail is set, there is not a referral to pretrial services. And we certainly see cases where bail is set and bail is posted. And so if those are situations where pretrial services might be helpful in increasing community safety, to keep in mind that even if bail is set, somebody still might be out, and to consider whether pretrial services could be helpful. So that's one piece I just didn't want to lose in our review of things. And then also just with a quick look at the progress report, and I was looking at the section about pretrial services, specifically on page 14. And there's a note there that says, and I think this is not accurate, but it says Superior Court uses pretrial electronic home monitoring and alcohol drug detection or testing to keep people out of jail prior to adjudication. And then the following paragraph goes into a range of kinds of pretrial services and monitoring options. And I know we've had some discussion about that. There's been some input from the county on that. I'm wondering if we could plan a time to have some more discussion about some expanded kinds of monitoring, again, specifically where there might be behavioral health concerns that are very closely tied to interpersonal violence concerns. And how can we use our pretrial services unit to improve community safety if someone is going to be released or is going to be able to post bail. So I just don't want to lose those questions.
Thank you. Good points all. And I know that there is an alternative perspective, which is that pretrial services are a substitute for bail, not a supplement to bail. Personally, I think the disadvantage is you get on a slippery slope if you get into the habit of doing both, but there are times when that's warranted. And so I do think, Carol, that we need to be exploring this issue, perhaps not now, because we're sort of getting onto our new track with pretrial services and working with the court to fully utilize the assessment tool. This is something we should be bearing in mind, but I think once we get back on track with using the pretrial assessment tool, we can then look at the array of services. And I think the point you make is a very good one and one that we should consider. So does that make sense? I'm just saying we should consider it not immediately, because the immediate challenge is to get ourselves back on track. But that's an important point that we need to address. Yeah.
I would like to take up the question that Carol touched on that I think is still unresolved in this group at least, and that is the use of referral to pretrial services and the imposition of bail. And I don't think we've seen any data on who might have had both of those imposed and couldn't make bail and is still incarcerated. How many of, I don't think we know in a data sense what's going on there. And I don't know if that data exists. I guess, Stephanie, maybe you would have that if it does, but resolving the question of whether to use that uniformly together or just in certain cases where circumstances seem to call for it, as you suggested, Judge Garrett, and then how people are doing if they have both conditions imposed on them. It seems that would be a starting point for us to think about that. And then we can go beyond that at a later time if we're sequencing out our topics of debate.
I agree. And I don't know what data we have, and I don't know how much of it Stephanie would have and how much of it Dr. Peterson would have. Does either of you want to comment on that? I'm not sure that we've been keeping track of that information, in its own, for its own sake.
I don't have any specific numbers on that, but I am aware of the fact that they do set bail and assign pretrial fairly regularly.
Yes, that was my impression as well. Dr. Peterson, do you have any current information on that?
No, nothing current. I think, and I have to go back and check if bail information was included in the extract I got from the jail that I matched up to Alan's data. But if it is, the most current I had would be the last time we ran numbers, which was, gosh, a year and a half ago.
Yeah. Okay. Well, we may ask you to go back into your records to look for that information, but the time period that goes to up to a year ago is so distorted by the COVID considerations that I'm not sure we want to assign you that duty unless and until we know it's necessary. So maybe. I'm sorry, since I'm on my phone, I can't see any of you when I turn to the page that permits me to be unmuted. So if it seems kind of choppy from this end, it's because of the technology. Does anybody else have any comments they want to make at this point?
Yeah, I I'll interject one more thing, and going back to our numbers, I told you how many we're serving and things like that. I did, just for a quick reference, just see, and it's hard to correlate these two, but I want to draw this conclusion. So when I was in the office by myself in December of 22nd, I ran the numbers from December of 22nd of last year to January 22nd of this year. My compliance, so I did 76 of 93 check-ins. So that means I put 93 check-ins on the calendar. I completed 76 of them. I was at 81% compliance rate, which I think is pretty reasonable. And then when Kelsey was hired and we started going to first appearances more, we started going to more kind of random out of custody and in custody calendars. So that's January 22nd of this year to February 22nd of this year, and 128 of 142 were made. So it's 90%. So, and I also compared the two, 93 versus 142, and that's a 52% increase, almost 53% increase just in being able to do office contacts and things like that. And I think I will correlate that to us being in the court more, to us getting more referrals, to getting more people in the office. So just having Kelsey in this office, and she's learning super fast. She's trained on the PSA. She does a lot of office check-ins. She knows our processes and everything. I think that was a turning point for this office to pick up our client load.
That's excellent. I mean, it sounds to me like the pretrial services unit is really coming along, and you're doing some innovative things, which is exactly what we like to see. And I'm really glad. I'm hoping that we can clarify the role that the pretrial risk assessment will play with the judges and the commissioners, and give you a little more direction than we've been able to give you so far. But you've taken the rope and you're running with it, and that's great. I don't know that we have too much more to say. I've reviewed the Vera report and then the progress report of this past summer, and I think that the progress report is pretty accurate. It's talked about our work in developing pretrial services as a unit, and our work in developing the risk assessment tool. And it doesn't go farther than that to discuss the disconnect between our committee and the use of the assessment tool by the commissioners. But it describes, I think, accurately the work that we've done, and the move that we need to take forward, which is utilizing pretrial services to the maximum degree that we can, understanding that it's a limited resource and we have to use it wisely. So I was, reading the report card, I thought, what's this going to say about us? Because we have not moved ahead hugely in the last several months. But I thought that it depicted our situation accurately. Anybody else have comments or reactions to the progress report? Okay, well, that's pretty overwhelming silence. I think I'll take it as no violent objections anyway. I think that we have covered what we need to cover in our meeting today. I'm looking forward to Judge Jones integrating himself into our processes and facilitating good communication between our group and the judges and commissioners. And I'm willing to leave it at that for today and suggest that we have our next meeting in early April, the first Friday in April. What do others have to say on that?
Sounds good. Good to me.
Yeah, that should work.
Okay, I think that's what we'll do then. Anybody that hasn't yet read them, Jill has sent us a couple of emails with the Vera report and the progress report and the executive summary. So please, if you haven't already read them, please try to do that before our next meeting. And let's set our next meeting for the first Friday in April. I'm using my calendar as my phone here. So Jill, can you tell us the date that would be?
April 1st.
April 1st. Now there's an auspicious day. That's what we'll do unless anybody has a suggestion otherwise.
Wouldn't that be April 5th?
April 5th.
April 1st is a Monday.
Yeah.
April 5th.
Oh, okay. Then we want April 5th. Okay. That sets it then. 12:30, Friday, April 5th will be our next meeting. And in the meantime, I'll talk with Judge Jones about the history of our group. We'll all review the documents about the Vera report and the progress update. And I'll look forward to seeing all of you on April 5th. Okay, thank you.
Thank you.